is. Oh, you're in good hands. They say I'm gentle, so don't be scared. I'm a monster. Every train has its thrill. My game, my will. Pilgrim, don't let me, okay? No, I wanna be given the blame. Hold up, wait a minute, what you're talking about? Hold up, wait a minute, what you're talking about? Wanna be given the blame. I'm a fraud. 'Cause I'm a true psychopath. When you're lost, take your trust. That's me. That's so sick. I'm a fraud, call me a liar. A true psycho. Woo. I'm a fraud, call me a liar. A true psychopath, don't love me. When you're lost, take your trust. Yeah, that's me. Oh, that's me, that's me, that's me. Yes, I'm a fraud. Call me a liar. A true psychopath.
Hello. How is everyone? It's Sunday night. It's a big, busy week coming up. Let me say hi to everybody. Let's see. Let me scroll. Let's see. We've got Princess Megan Elsa. Hello. K Braze, AJ, B Crumbs, Pointer Lover, Carol freaking Claus, Petunia. Good to see you, Cutie Pie. Hello. Candace, hello, hello. Hello, Shani. Hello, Adrian. There's me. Elizabeth, hello. Hi, Music City Mom. Good to see you. Hey, Jane Doe, Elizabeth, Anaphylaxis. Hey, I've learned a lot. Good to see you, Candy Cane. Team Psych Ward, hello. Hi, Allie. Good to see you, babe. Hey, Eddie, don't worry. Good to see you. Emily, Flotia, good to see you. Deb, hey. Hey, Team Psych Ward. I thought I saw. Hey, Marcus, good to see you. Ah, there she is. There's my other half. Hey, True Psych Ward, good to see you, babe. Mrs. O, hello. Hello, hello, hello. Oh, it just jumped. Uh-oh. True Crime Crazy, Cement Shoes, ATS News. Good to see all of you guys. Hey, Pepper. Hey, Mrs. O. I don't remember if I said hi. If I did, you get 2 highs. If I didn't, there you go. Hey, Savvy's Aunt. Positive vibes only. Good to see everybody. Welcome in. All right. Ooh, so, before we get started, though, let's hear a word from our sponsor, and then we will get right into it because we got a lot to talk about tonight. Okay, here we go.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash! Yeah.
And our other sponsor tonight is?
No malicious.
Okay, so let's start there. Let's start with Sarah Boone. All right, let me get over here to the good old trusty YouTube. It's because I want to show you guys her appearance in court. They have not uploaded her letter yet. There is a letter, but they haven't uploaded it yet. I'm telling y'all, don't you worry. I go to the site all the time and I check and check and check so that when it does get uploaded, because eventually it will be uploaded. As soon as it gets uploaded, there will be a dramatic reading of the letter, especially because I'm given to understand that she revised a letter. So that's always exciting. So let me see. Here it is. Okay. Let's see if this is it. Give me just a sec. Here it is. All right. So let's start with that and then we'll get into it because I want you guys to I want to explain some stuff to you guys that I found out because I looked into some stuff. So I want to talk to you guys about that. So let me get this over here. Right click. Bruh. What are you doing, YouTube? Stop. Okay. All right. Now we're ready. Here we go. Oh, let me know, Mrs. O. I want, you know, I'm all about the Boone.
All rise.
Listen, bailiff, I know you're doing your job and everything, but you are obstructing our view, ma'am. I'm going to need you to scooch a little. Hey, Nadine, good to see you, babe.
Well, I got it back yesterday from English and finding somebody incompetent and
She's mad. Look at her face.
it was returned to me because none of these boxes were checked. Are they all, is it applicable to everywhere? Like,
Well, if he's not yet been convicted, trial, pretrial, control plea, sentencing. Those forms.
State of Florida versus Sarah Boone, 2020 CF 2603. Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10-10-77.
All right, we're here for a status hearing on your case. Your case was set for pretrial conference back on July 12th, but as I promised you, I was going to bring you over. So whatever the things that we normally discuss at pretrial would be discussed while you were present in the courtroom.
I'm going to explain it in just a
Mr.
second. I've
Banquets.
learned a lot.
In court, you previously discussed an issue with getting JAC to pay your expert, I'm going to just paraphrase, for this battered spouse defense. All right.
And they have filed a formal objection, which now has been set for hearing. I want to say September the 18th, is the first available time, because they have to have, they require 20 days for hearing purposes, and we couldn't get on your docket before that date.
All right. So,
Sarah is 46 years old. She's the same age as me. There's 10 months between us.
Mr. Cacciatore, Ms. Boone's present. Mr. Banquets is asking to continue the case so that he can, we're going to have a hearing with JAC on his request for funding for a defense expert. Given my understanding of the case, that defense expert would be crucial to at least one defense that's going to be offered in case. And my understanding is you can't do anything until that expert actually is identified as a witness who's going to be called, correct?
That's correct.
She has been identified.
I understand, but it's not unknown at this point whether she's going to be called. And I assume since there's no agreement as to payment, potentially there's going to be an issue with the state deposing her at this point in time.
Right.
So that's what I meant by he can't do anything until you get to the bottom of what she's going to be paid and whether she's willing to formally accept the case. Is that a fair statement?
Semi-fair. She is formally willing to accept the case. The issue is the hourly rate. JAC hasn't changed their hourly rate for this area of expertise for over 10 years.
So, Mr. Cacciatore, the request is to continue so that that issue can be resolved. Do you have any objection to that?
No, Your Honor.
All right. I'm going to grant the request to continue under the circumstances.
I can't wait for her letter either, True
What's
Psych
the hearing
Board.
date
No.
that we're currently working with,
I
Mr.
want to
Banks?
say September the 18th, Judge.
That sounds like what my JA told me as well. For control purposes, I'm going to set the case for my September 20th pretrial, October 2nd trial period, with the understanding that we can potentially address pretrial. And I understand that you're unlikely to tell me that you're ready to try this case on October 2nd, regardless of what happens to the 18th.
Correct.
But I just want to have the case scheduled close in time to the 18th so we can address them at the same time.
Thank you, Judge.
All right.
Have a good
That
day.
is the order of the court. Ms. Boone, you'll be returned to the Orange County Jail while Mr. Banquets continues to prepare your defense. All right.
Judge Boone,
Thank you, Judge. Have a good week.
Hold on one second. Ms. Boone, I've addressed pretrial. I've brought you over. I'm going to give you a moment if you want to share something else with me, but that's what I needed to address today. And I've got other matters that I need to address in short order. So,
I understand, and I'm grateful for your time. I had previously sent you a letter, and it has not been uploaded, but it was made an announcement to the courtroom during my pretrial that you do have it, and I was wondering why and if it will be uploaded, because I have another copy of it that I would like to hand deliver to you today.
I don't know why it has not been uploaded. I'll have to talk to my JA about that. If you want to give me another copy, that's fine.
Yes, please.
All right. Go ahead and just tender it to one of the deputies. And actually, any objection if I just have the clerks scan it here in open court?
Yes, please. And do I normally get a copy? I haven't gotten one. I'm sorry.
You
Well,
wrote the
we
letter.
filed
That's
the
your
case.
copy, weirdo.
If it's uploaded, Judge, I can make a copy and take it to him.
Okay. All right.
Yes, please. If that would be okay, I would like to have that one uploaded. It's revised.
Okay. And what I had directed my judicial assistant was to disclose this to the attorneys. Again, to a great extent, when I read the original, you've covered a great deal of ground that we've covered in open court on multiple occasions about the method and manner of communication. Having read the original letter, I did not believe there was any additional action that I needed to take, which is why I didn't take any action on that letter. All right. So to be filed, Ms. Boone will be returned to the Orange County Jail pending further order of the court.
Thank you.
You're welcome.
All right. And as you can see, while Miss Boone's mouth is saying thank you, her face is saying, I've had enough. So basically, Lucia, this is Sarah Boone. She is in Orange County, Florida. Back in 2020, she was playing the most throwed off game of hide and seek ever and put her boyfriend at the time, George Torres, in a suitcase, zipped him up, and inadvertently went upstairs, laid down, and went to sleep. And Mr. Torres died from situational asphyxiation. And they charged her with second-degree murder in his death. And they've been trying to get this trial off the ground for 7 years. And they're not going to be ready in October, like they said. And so what's going to happen is they're going to push it to November. And once they do that, it was supposed to be tried in November of 2022. Okay. And this will make an entire year. It's been continued. She's already been in jail for since what, February of 2020. So she's been jailed now for 3 years pending trial. So that is basically the update. Now, what has happened is this. Hey, Mel Matt, good to see you. Okay. So this is the deal with the JAC. Okay. They've written a formal letter and all the things. And part of the issue is that, all right, so comes now the Justice Administrative Commission, JAC, by and through the undersigned attorney, and files this response to the above cited motion as follows. 1. Frank Bankowitz, counsel, is seeking authorization for $15,000 at a rate of $400 per hour for services and $120 for travel time for a defense mental health expert. Based on JAC records, the court previously appointed a mental health expert to assist the defense, albeit under prior indigent for costs counsel. JAC paid $7,500 for the services of this expert for services rendered from August 21st, 2020 through April 5th, 2022. JAC also has concerns about the rate requested for this expert. 2. JAC may only pay due process costs as authorized by Section 29.007, and then there's a couple other Florida statutes. Basically, JAC objects to any compensation rate in excess of established rate. And then it breaks down the rates. And they are pretty low. Number 5, counsel has the burden to establish that the particularized need for expert services. Counsels need to show the services are necessary for the defense of the case. Defense counsel also has the burden to establish diligent efforts to obtain services within or closer to the rates established by law. While an indigent defendant has a due process right to the assistance of experts in his or her defense, that right is not unfettered. Then it cites some case law. The defendant is not entitled to a specific expert or one of his or her personal liking, but it is only entitled to the services of a competent expert. Basically, they're saying, excuse me, they're citing more case law, and it's really about the well, I'll just read it. As enunciated by the Florida Supreme Court, an attorney seeking due process costs has the burden to establish 1, the particularized need for the due process services, and 2, prejudice arising from the denial of the due process service. 8, the determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must allow the trial court that there exists a reasonable probability that both an expert would be of assistance to the defense and that the denial of expert assistance would result in a fundamentally unfair trial. Counsel wants to establish the need for an additional mental health expert where the court previously appointed an expert to assist the defense and the expert conducted an evaluation of the defendant. Due process does not require the state to provide every foreseeable service to the defense. Rather, the state is only obligated to provide the basic tools of the defense. And then it cites about the United States Supreme Court. There's another one from out of Oklahoma. 10, in light of the services already provided to the defense, counsel has the burden to show the need for a second mental health expert in this matter. Although counsel may prefer the services of a preeminent expert, due process does not require the state to provide services that a wealthier defendant might elect to purchase. If the expert who has already evaluated the defendant can provide competent and meaningful service to the defense, the court should not appoint another expert in this manner. 11, counsel also has the burden to show diligent efforts to establish or to obtain services within the rates established by law. So basically, what they're saying is this: we've already paid for a mental health expert, okay? And yes, Drew psych ward, yes. So basically what they're saying is, hey, we've already dished out $7,500 for a mental health expert. Now, what do you need another one for? And I suspect that, I don't know what the, because it's all the way till the 2022. And Bankowitz was her attorney in 2022. So I don't know. I have to look up and find out exactly when he started on the case. But they may have been going for a different type of defense. So he's going to have to argue and explain it. And it sounds like the state is just like, she's already been evaluated, and too bad, so sad. We've already paid somebody, and just ask that witness the questions that you were going to have her have that person testify instead of the person that you want to testify. I'm thinking that the person they want to have testify, who's agreed to evaluate Sarah, is somebody who is more familiar or specialized in the area of battered spouse syndrome, identifying it and testifying, et cetera, et cetera. So there's that with Sarah. So it's going to be a minute for Sarah. So anyway, that's the deal with her. She's mad. And I can hardly wait to see her new letter so that I can read it to all of you guys in the dramatic reenactment. Oops, wrong thing. Because, I love to be reading a Sarah Boone letter because she just gets so dadgum mad. And she gets so she's mad. And I was telling people on Allie's channel when I was over there Saturday, but I'll say it over here in case you weren't there. By the way, that was a really fun live. We just chilled. You guys should check it out. But anyway, I am kind of, here's the deal. I believe that Sarah Boone is guilty. Okay. And she needs to be punished. All right. But I also believe in our justice system. And I also believe that she should get a fair trial, and she has the right to effective assistance of counsel. And she has expressed repeatedly, and I caught this when I watched it when it happened, but hearing it again with you guys made me think of something. So you know how she is, really doing the maths in all of her letters. Like that's how she always starts out. Well, I shouldn't say always, because the last letter started out with people, the definition of perception. So I'm curious if that word had extra hits on it after her letter. I highly doubt it. I think pretty much everybody knows what perception is, Sarah. I know that you're the smartest woman alive at all times, but we all know what that word means. Anywho, so, but what I noticed is, she's always adding up how many times she's tried to reach Mr. Bankowitz, how many times he's returned calls or answered calls or seen her in person, et cetera, right? And she even had somebody from somebody on the outside ask, to reach out to him, which I don't know what good that's going to do, Sarah, because unless you've signed something and it's notarized and you've authorized Mr. Bankowitz to speak to this person, that would violate attorney-client privilege. So don't try to entrap Mr. Bankowitz. I know y'all ain't seeing eye to eye. Let's play fair, ma'am. But that's been the crux of the majority of her letters. And the way that the judge said there was no further action for me to take, that's why I didn't take any further action, leads me to believe that he's looked into it as far as the visits between she and Mr. Bankowitz, whether that is in person or video call or however they do it, right? And found that he is doing what he's supposed to do. So we'll see. I think I'm gonna write though, and I just kind of want to check. I'm curious. I know which jail she's in. I know how to get like the prison records or whatever, the jail records. And I'm just curious. I really do want to do the math. I want to see if she's being on the up and up or if she's exaggerating, because I'm curious about that. I would have no way of proving whether or not this person that she's got reaching out to Mr. Bankowitz on the outside, I can't like verify that or anything, but I can verify her math from inside the jail, like when he's, seen her and stuff like that. So we'll see. I'm going to see if I can find it. Yes, true psych ward. I excel at everything. All right. Now for Taylor Schabusiness. Okay. So I did a little looking around today too in preparation for this stream so that I could keep you guys apprised of everything. I went to her docket. Yes, the jury has been sat. They've been picked, you know what I'm saying? They are going to start with opening statements at 8:45 Wisconsin time, which is Central. So I will be going live at 9:30, and we're going to stream the trial. The only time that I am a little bit concerned, and I kind of want to get you guys' opinion, because everybody that's in here now, I'm guessing is in here because they want to hear about Taylor Schabusiness, which means that they are interested in watching the trial. So it's your opinion that I really want to hear. I was thinking that it might not be a good idea to stream the medical examiner live, but rather do a recap that night. And I want to know how you guys feel about that. Well, yeah, I mean, yes, you're right, Mountain Mirrors. Time served does count. I mean, she will get credit for time served, but she can get life. So with her charges. So, I don't think that I have to look into this. I don't know that Florida has the way that Wisconsin does, like truth in sentencing. So I'm not sure. I have to look at that. I haven't looked into Florida's sentencing in a really long time, because all the cases that I've ever covered in Florida have been basically, you're either going to get the death penalty or you're going to get life without possibility of parole. And those are pretty cut and dry, right? So we'll have to see. I'll look it up for you guys. But yeah, I just wanted you guys, I'm just curious how you guys feel about hearing that type of, if I should stream it live or not. I'll do whatever you guys want to do. I'm just, it's kind of made me think, ever since last week and whatnot and everything. I just want to be more sensitive and more careful. But it's up to you guys. So anyway, that's what we're going to be doing now. I will say that I'm curious what is going to happen during court. And the reason I say that is because this is not the right one. I don't know why I just clicked this. The reason I'm curious about what's going to happen with Schabusiness is because, let's be honest, as long as Schabusiness is on her meds, right? She's able to behave in a courtroom, right? She's not attacking anybody. She can sit there, all the things, right? So I'm curious how they're going to be with her, as far as are they going to make her take her medication? Are they going to be closely monitoring her? If she decides not to take her medication, are they going to like give the court a heads up and they're going to take different types of protocols with her? I'm just very, very curious. Hold on a second. Let me type something in, that way this will be better. It'll give me better search results, because this isn't, I want to watch the first one, not the second one. Hold on. Let me find. Yeah, I'm really curious about how it's going to go with Taylor Schabusiness. Let me see something really quick. Hold on, I'll go here. This is what I'll do. Let's see. So the way I thought we would do the trial is in parts. So I'll stream, from 9:30 to whenever they take their lunch, right? And then stop and then come back after lunch. That way people, we can get up, move around, do all the things, you know what I'm saying? Bro, what is the problem here with law and crime? So it's the way their YouTube is laid out on their website, rather than like on a browser, versus the well, I'm done looking. I'm pissed off now. We'll just watch the one that I wanted to. We'll just watch the second part, 'cause that's the important part. This is the one where they find her competent. So we'll just watch that. By the way, everything is coming in. Okay. Her, you want me to take a poll, Carol? I will take a poll. Give me just a second. Everything's coming in. The interrogation video that the defense wanted kept out, that's coming in. All of the things that they tried to get to not come in are coming in. So there you go. All right, so let's watch this. This is going to be the state's witness. And he evaluated Taylor, and these are the things that he found. And while we're listening to him, what I'll do is I'll be looking for the other one that I wanted you guys to watch, because it's her expert. And then I'll put up a poll. Sound like a plan? All right, I'm going to turn closed captioning on because it's super hard to hear the audio from this. So, because he's testifying via, so he's just on a monitor. They don't have like a mic up to it, so it's kind of hard to hear. And we all know that that the closed captioning through YouTube, it struggles. There's a lot of words that it doesn't pick up correctly. For example, if you're paying attention in the other one, they called Mr. Banquets banquets. That's what they called them, banquets. All right, here we go. Let me add this to the stream. Make this big. All right. All right, and I will go and make a poll real quick. Let me mute me though.
September of 2020, and I've continued with the practice since obtaining my psychology license in February of 2022.
So I object on foundation.
I think he has given a sufficient foundation. He listed all of the things that he did, including reviewing all of his records, conducting report, outline some concerns that you have with Dr. Litton's report.
Yes, it does.
Ultimately, do you come to the same conclusion as Dr. Litton?
No, I reached the opposite conclusion with respect to the issue of competency.
And what is your conclusion with respect to Ms. Schabusiness's competency in this matter?
So the opinion that I offer to a reasonable degree of professional certainty is that the defendant is presently competent to proceed.
And your report lists a number of reasons for that opinion, does it not?
It does.
And I would like to just sort of walk through some of those reasonings if we could. First of all, you address, I think, the issue of her background materials and I think the threshold question of whether or not she has a mental illness. I'd like to start with that supposition. What is your opinion with respect to whether or not Ms. Schabusiness currently suffers from a diagnosable illness?
I would object on foundation. I don't know if there are enough questions asked to render an opinion at this point. So I object on foundation.
I think he has given a sufficient foundation. He listed all of the things that he did, including reviewing all of his records, conducting his own personal interview with her, and evaluating all of the available materials in this case.
Overrule the objection. Go ahead.
And so after reviewing the totality of those data sources, I noted that sometimes in the defendant's history, she perhaps has experienced clinically significant depression, has contemplated suicide, has had various behavioral issues, although I found no evidence to sustain an independent diagnosis of a severe mental illness, such as bipolar disorder, schizophrenia, or a like condition.
And with respect to the defendant's own reporting of having such a mental condition, what did you note?
I noted that there's been a remarkable inconsistency in the extent to which she has endorsed having a mental illness such as bipolar disorder, and instead of many occasions has ascribed any related or similar symptoms squarely to her abuse of intoxicants, most notably methamphetamine.
And did you also review information about her recent behaviors, whether that occurred in the jail or in court proceedings and things of that nature?
Yes, I did.
And what were your observations with respect to those recent behaviors and how they might impact a diagnosis of bipolar?
Yes, I noted that there certainly have been behavioral issues within the jail and in the courtroom, and I am certainly well aware of the assaultive behavior towards the previous defense attorney within the courtroom. I'm aware of the defendant throwing a chair at Dr. Litton. While certain such behaviors certainly are disruptive and concerning, I found no evidence to suggest that there was a consistent pattern of such behaviors that could be directly attributed to symptoms of a mental illness. Rather, I am fundamentally unable to rule out that they're primarily volitional
In particular, let's deal with the issue of her throwing a chair at Dr. Linton. What concerned you about that particular incident in terms of your ability to assess whether that was related to mental health or volitional conduct?
So certainly if that were a pattern of behavior that was consistently occurring and seemed to be out of control, that could be an issue relative to competency and attending to and meaningfully participating in proceedings. Although again, it was an isolated event. And there's noteworthy that after immediately, at least according to Dr. Linton's report, immediately after the defendant did such behavior, she calmly sat back down, which is inconsistent with someone in a state of psychotic agitation, who typically would require significant external intervention or chemical or physical restraint